Agency law is our topic. We shall look at agency law. Then, obviously, I told you that the business law consists of introduction. Then introduction has so many subtopics, which we looked at the beginning. Then we have, from there, we proceeded to the law of contract. Now we are starting agency law, and we shall end with the partnership. I will not discuss company law because company law is a separate question for BBA. BBA 3.1, we will study company law exhaustively as a question on its own. Therefore, company law won't be part of the of our, I mean, it won't be on the outline or curriculum as far as business law is concerned, since you will study it separately. So as you are revising, make sure you revise introduction, contract, the law of contract, agency law and partnership. We no longer examine a Sale of Goods Act. So you can ignore sale of goods, and then company law you can revise on your own, especially BBA, so that when it comes to 3.1, you will have prior knowledge, since it is a question on its own. So let us look at agency law, and we define it. An agency can be defined as a relationship which exists whenever one person called the agent acts on behalf of another person, and that another person on whose behalf the agent acts, we call him a principal. So agency is a relationship that exists when one person who is called an agent acts on behalf of another person called a principal. So we have an agent acting on behalf of the principal. Where such a relationship exists, the acts of the agent are said to be the acts of the principal. Therefore, in the case of any liability arising from such acts, then the principal may be held liable. The acts of the agent are said to be the acts of the principal. In the case of any case arising out of the relationship, the acts of the principal can also affect the acts of the agent can also can affect the principal, since it is the principal who appoints the agent. So an agent is a person who is employed to do work on behalf of another person called the principal. And the law of contract generally applies to the agent's relationship. That's why in contract we have privity of the contract. Therefore, and I hope you understand the meaning of privity. Only parties to the contract can derive benefit out of it. Therefore, the contract recognizes agency. That is the principal and an agent. However, agency itself forms one of the exceptions as to the doctrine of the privity of contract. This means that when an agent enters into a contract with a third party, then the principal is considered to have been a party to that contract, even if he was not physically party to it. He can therefore be sued by the third party as if he was a party to the contract. This is because of the fact that he who acts through another acts himself. Now let us look at the capacity of an agent and principal. Having defined an agent, and we have also said that even agency also applied to the law of contract, let us look at the capacity of an agent and principal. Capacity, what do I mean? We want to see whom can the principal appoint as an agent and whom can a principal not appoint as an agent. Any person with legal capacity to enter into a contract can appoint or be appointed as an agent. However, while a minor can act as an agent of a principal, a minor cannot appoint an agent. And a minor is a person below the age of 18 years. A minor can be an agent, but cannot appoint a principal. I mean, a minor can act as an agent, but he cannot appoint an agent, meaning a minor cannot be a principal, because a minor is below the age of consent. This is because he's likely to choose the wrong person, since in law, we say he has not attained the age of consent. He's below the age of consent, and the age of consent is 18 years. So that means that the minor lacks the capacity to act as a principal, even as though he can be an agent. So that is the first instance. Minors can be agents, but cannot be principals, because the minor has not yet attained the rightful age. Why does he become an agent? Because if he's appointed by the principal, we take it that the principal is above 18 years and he knows what he's doing. But the minor is below the age, therefore he lacks the capacity to appoint a principal. Number two, persons of sound mind, whom we also call lunatics. The general rule is that where the party to the contract is of an unsound mind, the contract is still binding on him or her, unless he or she can prove that he was insane at the time of the contract, that he didn't know what he was doing, and this was known to the other party. What does it mean? That if, for instance, a principal appoints an agent, but you find that he has appointed an agent and he reasons that he was mad, he must prove that that madness existed at the very time he appointed the agent, and that it also had a bearing on the contract. Otherwise, if there is no evidence or proof to that effect, then the contract is binding on only the principal. So persons of an unsound mind also are not supposed to become agents and principals, but there must be evidence to the fact that one is mad. It is not merely alleging that someone is mad, but there must be concrete evidence. We proceed. A mentally incompetent person can only appoint an agent during the lucid interval. That is during an interval when he's capable of understanding what he's doing. So he must appoint when he has regained his conscience and he is normal. But in case a principal appoints an agent when he is in that state of madness, then that contract is not binding at all. We proceed. Then let us look at companies. Companies can be appointed to act as an agents of individuals or other companies as long as they have been registered as required under the rule. Companies, they possess the contractual capacity to be agents and principals, because as we shall see, a company is either a company is an artificial person, is not a natural person, artificial person. A company